to argue that the present case is inadmissible. They have they have cited a rule in relation to non-exhaustion of international regional remedies. This has been swept aside by my colleague Tresor Moindo, who took the floor before me. So I'll not go back to that. In Rwanda, also made reference to two pretexts. First of all, Rwanda expect to obtain from your court the inadmissibility of the application of the DRC on the grounds that the applicant ought to have and didn't exhaust international and regional remedies available to it. Secondly, that DRC did not respect the preliminary requirements, did not respect the preliminary non-judicial procedures required. I'll methodologically to counter these arguments brought before you. Honorable Vice President, honorable judges, the alleged non-exhaustion of international regional remedies is not a requirement nor a legal obligation for the admissibility of the application of the Democratic Republic of Congo in the instant case. Indeed, let me recall that we are here having before us a confusion orchestrated by the Rwanda relating to the remedies provided for in Article 50 of the Charter and an alleged exhaustion of international regional remedies, which according to them flows from traditional rules as well as diplomatic protection, which they brought forward against the arguments of DRC. Rwanda finally admitted that this is not a context of diplomatic protection where the rule of internal exhaustion of internal remedies would apply. My predecessor brought up arguments to show that the limitations of the arguments relating to the exhaustion of local remedies. In an event, probably in a miraculous manner, that this rule will be accepted by the court, Rwanda does not indicate any reference, does not give any reference that will which will serve as a basis in relation to the international regional remedies, and they do not indicate any procedures, any relevant procedures. In Rwanda, therefore, limited itself to a citation of previous practices in relation to the Vienna Convention, the right of treaties, and to conflate it to the exhaustion of international regional remedies in Article 50 of the Charter. Honorable Vice President, honorable judges, the learned professor on the other side said that this is the practice between practices, whereas it was necessary to identify the alleged a practice which is applicable, and then we need to verify if the DRC considers this to be an applicable rule, and in any event the DRC objects to this. Using this malicious intellectual gymnastic, Rwanda is trying to give a wider scope to this article of the Charter. The African Commission on Human and People's Rights, which is not the same as the rules of this court, let me point out, Honorable Vice President, Honorable Judges, to what extent Rwanda is allergic to the Commission when they say things that, when the Commission says things that are not in their interests. Either the problem is that there as well, the reasoning of Rwanda has legal problems. Normally, they talk about the what can be gleaned from the decisions of the Commission. How then can they reject some of the decisions of the same Commission when it does not favor them? Now they come to appeal to your jurisdiction, the application of the rules of court of the same Commission, whereas the court has its own rules of court, which logically should take precedence in our situation for purposes of relevance and accuracy on the issues before us. Honorable Vice President, Honorable Judges, in any event, it is based on their reasoning that Rwanda is claiming that DRC should have attempted negotiations in relation to the alleged conflict or sought the good offices of the UN before coming before you. And they are saying that when you examine the examination of the context of the African Charter, support this conclusion, because all interstate procedures will require a prior dialogue between the states involved in pursuance to Article 44, and give them time of reflection to arrive at a mutually satisfactory solution, which is not absolute. The DRC would like to point out that the internal remedies provided for in Article 50 of the Charter relate only to the framework of diplomatic protection, which unfortunately for the respondent state is not the object of the instant case. We can never overemphasize the fact that the rule of exhaustion of internal remedies, which Rwanda is attached to, does not apply here. It's not relevant here. And in a matter between the two parties before the Commission in 2003, and here I believe that Rwanda is not going to deride the relevance of this case that I'm citing in support of the rules. It said that when the acts underpinning the alleged violation of human rights occurred on the territory of the applicant state, there's no issue of exhaustion of internal remedies, and that this does not apply. Similarly, as your court has already asserted this in Alibi Igame versus Tanzania, no prior procedure is required in such circumstances. when DRC decided to come before your court, no valid legal reasons requires it to go through any prior procedure before coming before you. Further, Rwanda's attempt to extend the scope of application of Article 55 through the interpretation of Article 102 of the Rules of Court of the Court creates further problems. Apart from being inaccurate in international law, it is not well grounded. First of all, because Rwanda raises this objection before your court on the basis of a rule applicable before the Commission in the rules of that Commission, Rule 109, which is the basis for going before the Commission and not before your court, and looking at things closely in point 2b. The rule provides that the communication should contain information on the following elements to be accompanied: B, measures taken to exhaust regional or international to resolve the matter. Honorable Vice President, your honorable judges, such a provision cannot be relied on before your court, where auxiliary measures of exhaustion of the measures before it, and this is not one of the requirements. Further, given the fact that the court's rules of court in its 2010-2020 versions did not make any such requirement extending the Article 50 of the Charter, there's then nothing to make such a suggestion. According to Rwanda, the absence of the requirements of Article 50 of the Charter suggests that the remedies to be exhausted will also include international regional remedies. Rwanda is also trying to mislead the court in relation to Rule 109B of the Rules of the Court, which makes specific reference to regional or international remedies and not remedies in general. As they claim, and wrongly so, such a manipulation cannot be tolerated by your court and should be dismissed with all the consequences that flow from it for Rwanda. Given the fact that this is not a conflict in the classical term of the sense, there's no reason for the Democratic Republic of Congo to have recourse to the said international regional remedies that Rwanda is making reference to, Article 46, 47, by conflating it with other requirements. DRC would like to clarify that the procedures provided for in Article 47, 48 of the Charter are the basis of measures to be exercised, and they provide as follows. If a state signatory to the Charter violates the provisions, it could, through a written communication, draw the attention of the state to the attention. This is Article 47. If within a period of 3 months from the date of reception of the original communication, the issue is not resolved to the satisfaction of the two states involved, through negotiation, bilateral procedures, one or the other will be entitled to submit the matter to the Commission through a communication addressed to a correspondent address to its president and to other instances of the African Union. That is Article 56. DRC points out that Rwanda deliberately avoid mentioning Article 49, which specifies clearly that notwithstanding the provisions of Article 47, if a state party to this party and another state also party to it may directly address a communication to its president, Secretary General of the AU, and to the state involved. All these provisions of the Charter establish the establishment of a truth, that is the latitude or the possibility to negotiate, which is a possibility given to all states party to the Charter. If they find it necessary, it is neither an obligation nor a precondition to be satisfied before coming before your court. As the court may observe, Article 48 is permissive and not mandatory. We agree with our colleagues on the other side. Just as they can come directly before the court, in one or the other case, the Article 48, provisions of Article 48 will have to be respected. DRC has decided to come directly before the court because it believes that Rwanda has violated and continues to violate human rights protected by the Charter and other relevant instruments in relation to human rights. How then can we imagine that while on the field human rights are being violated, human rights are being overlooked, entire ethnic groups are targeted by military groups? How then do we start with negotiations with a state that has genocidal intentions? Article 49 of the Charter, overlooked by Rwanda, makes mention to this possibility granted to DRC. The court will observe that Rwanda does not counter the arguments of DRC on this permissive and non-mandatory of Article 47 of the Charter. It would be improper to interpret the Charter not in its totality but based on specific provisions. Honorable Vice President, honorable judges, with your indulgence, I would like to move on to my next argument. As a precondition, among these preliminary procedures, Rwanda claims that Rwanda did not exhaust procedures enabling it to resolve the conflict through investigation, and that it ought to have followed the mandatory preliminary procedure prescribed by the African Union. Rwanda claims that the matter is based on political issues of peace and security, which is wrong, and claims that the DRC should have gone through these preconditions. The obligation to respect the procedural measures provided in Articles 28-29 of the Great Lake Pact cannot be applied to this case. The procedure prescribed in those provisions do not really apply to the African court, which is a specialized court on human rights, as we said yesterday. It relates to the general mechanisms, general justice mechanisms within the African Union. So that procedure is applicable when there is a conflict requiring the interpretation and application of the Charter. Rwanda went as far as claiming that human rights violations for which there are perfect reasons to believe that they are the authors are political issues relating to security, and that there is nothing relating to human rights violations. And then they go on to suggest a procedure provided for in Article 29 of the Pact. Given the applicable laws, it looks like they want to constitute an obstacle to the work of the court. They have the vain attempt to characterize their activities differently is to divert the jurisdiction of the court. Let's assume that DRC fail to comply with the preliminary procedures. Rwanda recognizes that the court they are referring to is not a court of the African Union, and this court will therefore does not have to respect the requirements of another court. We are here before a confusion which is in the imagination of Rwanda when they need to overlook the truth. And this is due to a misunderstanding of the African Union Charter. The court will therefore not show any indulgence to those who, out of bad faith, are trying to. It will be wrong for them to bring this argument before this court. DRC therefore invites the court to dismiss this argument. It is here I'd like to conclude my submissions, Honorable Vice President, Honorable Judges, and I thank you for your kind attention and request you to give the floor to Lawyer Jean-Paul Mwanza to continue with the plea of the Democratic Republic of Congo.
Honorable Vice President, Honorable Justices, I would like to thank you for giving me the floor to continue the plea of the DRC as regards the compatibility of the submission with the Constitutive Act of the African Union and the origin of the sources mobilized by the DRC to support its application. Rwanda has talked about a number of legal provisions that all refer to Article 56 of the African Charter in order to reboot the the admissibility of this application, which are not founded and not grounded, as I will explain it later on. Rwanda